Namaste friends, let us take 10 more questions in this video and learn. As always, keep your copy of the Constitution of India handy or the app on your mobile phone. Pause the video after every question, mark your own answer and then proceed to listen. We are going to discuss questions number 71 to 80 that were posted on the Telegram channel. If you wish to check the channel out for all these questions, please see the link in the description of this video. So let's get moving. The first question in this is 71. Which of the following statements is or are correct regarding the Union Executive? And the first statement reads that its powers, that is the Union Executive's powers, extend to the matters with respect to which Parliament has the power to make laws. Now this is a correct statement. If you read Article 73 of the Constitution, it very clearly writes there. So please refer to Article 73. It says, subject to the provisions of this Constitution, the executive powers of the Union shall extend to the matters with respect to which the Parliament has power to make laws. It's pretty much basically a copy-paste statement. Read the rest of the article yourself as well. A second statement says every executive action must have a legislative sanction. Now that is not really necessary. Yes, an executive action cannot be violative of the legislative sanction, violative of any legislation, but it's not really necessary to always have a legislative approval for all the actions made by the executive. And the best example of this is the creation of Niti Aayog. It's a body created by an executive action just by a resolution of the Union Cabinet. There is no legislative approval behind that. So the correct answer for this should just be the first statement. Moving on to the next question. Which of the following presidents of India had the shortest term in office? A factual question, but I would expect that if these kind of questions do come, or something similar to this, you use some logic to at least eliminate half of the options. Now see, most likely why would a president have a term less than their standard term of 5 years? Perhaps because of a vacancy that was created. Now we know there were two presidents of India who actually died in office, Zakir Hussain and Fakhruddin Ali Ahmad. In fact, the rest two here, or anybody else also who became president, they completed their entire period of 5 years, that is 60 months. Now, matter of fact, Zakir Hussain had a term of 24 months, while Mr. Fakhruddin Ali Ahmad had a term of 30 months. So the correct answer here should be Mr. Zakir Hussain. So that's your correct answer, which not many of you got it right. Anyway, next is which of the following statements are correct regarding the office of the Prime Minister? Prime Minister has a term of 5 years. No, there is no term of the office of the Prime Minister. There's nothing fixed there, nothing specified. Yes, Lok Sabha has a term of 5 years, but the PM may even have a term of 13 days like Mr. Vajpayee. Or 13 months or any amount of time. But yes, the maximum time in one go can be 5 years because of Lok Sabha, but there is no term that is fixed. So this is actually a wrong statement. Then PM must be an elected member from either house. No, it's not necessary. Why should you be elected? You can be nominated also. Now, generally this does not happen, but you can be a nominated member also. So it's not necessary that you should be an elected member, or you shall become even one within 6 months. You can be nominated, and this we are seeing in the case of Chief Minister in Maharashtra already, that they are exploring the nomination route. So this is also a wrong statement. Third one says PM is the leader of both the houses of Parliament. Of course not. How can he be or she be the leader of both the houses? They'll be the leader of the house where they are a member. So Narendra Modi, for example, right now is the leader of Lok Sabha, while Manmohan Singh earlier was the leader of Rajya Sabha. In the other house, somebody else from their party, which the PM only decides, they do the work of being the leader of the house, of that house. So yes, this is also a wrong statement. All three are wrong statements here. Next is which of the following statements regarding the office of Vice President of India is not correct? Mind it, not correct. All members of parliament vote in the election of the vice president of India. This is actually true. So that is why this is not a correct answer, even though the statement is correct. No woman has ever held the office. This is correct. No vice president of India has ever been a female so far. So this is a correct statement, but a wrong answer for the question. In case of vacancy, election to the office shall be held within 6 months. This, I think, just in the previous video we have seen that Article 67 makes a provision that it's not necessary. So this is a wrong statement, and hence the correct option for this answer. So it's kind of a repetitive idea, at least, that is being tested. Should not have been difficult, but anyhow. Next, no demand for a grant is to be made before Parliament except on the recommendation of. A straightforward question from the Constitution. I would refer you to read Article 113 Clause 3, and not a surprise, most of you actually got this answer decently right, that it can be done only on the recommendation of President of India. Moving on to question number 76. The tenure of Lok Sabha normally shall be 5 years from the date of. Again, a straightforward question directly copied from the Constitution. If you read Article 83 Clause 2, please do that. You will see that the first sitting of the newly elected Lok Sabha is the point from which 5 years are counted. Of course, it can be dissolved before that also. So that's precisely the language in Article 83 that you will see there. Next one is, which of the following statements regarding the strength of judges in higher judiciary is correct? First statement, the number of judges of the Supreme Court of India is as decided by the Parliament by law. This we have seen in the previous video itself, where I told you that there is number of judges of Supreme Court Act 1956, which was recently amended. Anyway, you shall please read Article 124 once for this. Then the number of judges of High Court of a state in India is decided by the President of India. This is also a correct statement. I will refer you to Article 216. It very clearly mentions that every High Court shall consist of a Chief Justice and such other judges as the President may from time to time deem it necessary to appoint. So if you have read the basic articles, otherwise also through your books, you should be able to answer this easily. So the correct answer here should be both of these statements. So we move on to the next question. Which of the following principles is not considered a part of the principles of natural justice? Now let's quickly understand principles of natural justice. Essentially, there are just two maxims. There are just two maxims, these two actually. As it is understood in the common law countries. From these two, many rules have grown to take care of new situations. Audio ultram partem, which simply means that, listen to the other side, hear the other side. And the second one, which means no one to be made a judge in their own cause. I cannot check my own answers, of course. So these two are the essential principles. Now, when you see res judicata, it means a matter judged and settled. So it's a principle, for example, it is embodied in the Code of Civil Procedure also. And the principle is that when an issue of fact has been tried by a court on a former occasion, then the finding is final and binding on both the parties, and it cannot be raised again. Now, this actually has got nothing to do with natural justice as such. The fourth point here, the reasoned decision, it is part of ensuring a fair hearing itself, or what we say a fair trial. Supreme Court of India has been ahead of the courts of England to lay down that fair play demands obligation to state reasons in the decision. This is what you will hear in the administration also as a speaking order. So I always like to say this, that these natural principles, these natural principles shall become part of your thought process in daily life, so that you become a more fair, if not a better decision maker. Gradually in your administrative career, it will help you even furthermore. So these three are the principles A, B and C of natural justice. Since the question asks which is not part of natural justice. So your correct answer will be option C here. Anyway, so we move on to the next question. Which of the following parliamentary committees have members from both the houses of parliament? This is just checking your basic understanding of the committees. Now, the Public Accounts Committee, we know the maximum number of members can be 22, where you have 15 from Lok Sabha and up to 7 from Rajya Sabha. So it has from both. Then DRSCs, these DRSCs can have 31 members, out of which 21 come from Lok Sabha and the rest 10 from Rajya Sabha. So they also have both houses participate here. Now, Estimates Committee, it has members and they are all from Lok Sabha only. So Estimates Committee is from Lok Sabha, they are all elected there. So this is not where both houses are there. Then the Committee of Privileges, this belongs to each house, and for each house there is a separate committee of 15 members. So in a specific committee of privileges, you'll have the members only of that particular house. So this is also not a correct option here. So the correct answer should be 1 and 2 only. Coming to the last question of today's video, deadlock between Lok Sabha and Rajya Sabha calls for a joint sitting of both houses for the passage of which of the following? Now, ordinary bill, we all know that yes, joint sitting is totally possible. For a money bill, since Lok Sabha has overriding powers over the Rajya Sabha, Lok Sabha's decision is final. There is no possibility there of a joint sitting, so it will not happen in case of money bill. Motion of thanks to President's address and motion to impeach the President of India. Please understand, there is no joint sitting for any kind of a motion. Joint sitting is always there only for bills, okay? Only for bills where legislative process is happening, legislation is being made. For motions, resolutions, all these kind of things, there is no joint sitting. So the correct answer for us here should be just your ordinary bills. So that's the 10 questions for today, and today I'm going to leave you with a message from Tathagat, Gautam Buddha. One of the very important lessons he has spoken to us in simple words, Apadipo Bhava, which means be your own light. I'll see you in the next video with 10 more questions. Till then, study well. Thank you very much.